that we're talking about. I will introduce Dr. Jessie Owley, who is at University of Miami, who I will note started her law teaching career at Pace Law School. And Jessie is perhaps the leading expert on easements as conservation tools, and is an expert in land conservation broadly. And then I want to introduce two special guests who are not on the conference agenda, Harrison Bench and Natalie Lara. So you might, yeah, they do deserve, yes. So you may notice that one of the panelists, Tracy Roberts, is not on the panel. She was not able to make it because she wasn't feeling well. But I think it was Professor Crawford's idea to have some students involved with the panel, which was a really, really good idea. And so what they're going to do is serve as commenters on the two conversations today. And they'll each take some time when Heather and Jessie are complete. They will take some time to offer feedback and commentary. So let me just say, Harrison Bench you're a 2L, right? Harrison is a 2L at Pace Law School. He's part of our dual degree program at the Yale School of the Environment, where he'll be beginning next year. And he's been involved in just about every single thing at Pace Law School. It's really remarkable, except he has not taken any of my classes.
Not yet.
Not yet, anyway. And Natalie Lara, who is one of the co-editors-in-chief of the Pace Environmental Law Review, and has also been involved in a lot of things at Pace, but perhaps not as much as Harrison, but she has taken 2 of my classes. So I'm going to sit down. That is enough of an introduction, and I will turn it over to, I think, Jessie first.
Yeah, so but those are
this is
Heather's slides.
Well, Heather, do you want to go first?
Yeah.
I don't think
I could try and do Heather's. No, I can't.
Yeah.
I have no idea what those words mean. So
I guess I'm going first. Okay.
do it.
So I always love being in the afternoon, right before the reception, and getting to talk about the second largest waste stream in the United States. So as hopefully everybody is well aware, the largest waste stream in the United States is standard municipal trash. And we are going to be, for the next 15 minutes, talking about the second largest waste stream in the United States, which is coal ash. So let's go ahead and get started. First of all, let's do some level setting about where coal ash comes from. So when we burn coal, we end up with different waste streams, which collectively are coal ash. And some of this is the heavier particles that actually settle in the furnace. A lot of it actually comes from the flue streams, so the lighter particles that end up in the air. And so we actually started producing even more coal ash as we went ahead and implemented the Clean Air Act, because of course, as we wanted to get rid of it or get it out of the air, it had to go somewhere. It doesn't just disappear. So we actually get it in different places. Each of these different ash streams have different components that end up with them, but that's where we get it all, mix it all together typically, and that's ash. Now, it has a whole lot of stuff in it. Now, all of these are originally essentially contaminants in the coal. Everybody who burns coal would be much happier if it was solid carbon, but it's not. We end up with aluminum, antimony, arsenic, barium, beryllium, boron, cadmium, chromium, chlorine, cobalt, lead, manganese, mercury, I can't even pronounce the next one, nickel, selenium, vanadium, and zinc. For any of you who remember your chemistry, many of these are hazardous. So this is what we end up with in coal ash. So a lot of things that we don't typically want in places like our groundwater. Where is coal ash currently stored? You'll notice it is all over the United States. Every single one of those dots that is not green means that it is either in an unlined unit, which means that there is no barrier between the coal ash and the underlying water supply. Or if it is a yellow dot, it means that we haven't quite gotten that data yet. What does that probably mean? That probably means it's also unlined, okay? So the only places that realistically we are making it so we don't have a groundwater problem from this material is the green dots. There's not very many green dots on that map. So what does that mean that we have to do? Well, a lot of the questions that come from this are, well, why are we talking about it now? There were two very large coal ash spills that happened in the United States. First one was Kingston, Tennessee in 2008, 3 days before Christmas. And it coated 300 acres and dumped millions of tons into local waterways. It also took about 8 years to clean up. Not all of it is cleaned up yet. And of the roughly 800 workers who actually cleaned up that spill, more than 50 of them have died of cancer. Almost all of those cancers directly related to handling the ash material. Second one was Dan River in North Carolina in 2014. Those two combined actually forced the EPA to go ahead and issue the first federal regulations that existed around coal ash in the country in 2015. So we finally went ahead and had regulations, but the first part of that was really a large data collection effort. Before we started gathering data around that regulation, we didn't even know how many coal ash facilities or ponds there were in the United States. There are over 1,000. And 79 of those are held back by high hazard dams. High hazard dams are basically ones that will lead to a loss of life if they fail. There are an additional 230 that are significant hazard dams. So we've got a large environmental problem. We also are seeing dozens of sites now that we are actually testing that have ongoing groundwater contamination in them. It's a valid question, I think, to say, okay, well, if we know what this is, we know that this is impacting groundwater, why are we not actually classifying under the 2015 rule coal ash as hazardous waste? Because we're not. We are actually treating it the same way as municipal trash under RCRA. And I would say there's two reasons for that. One of them very practical. The other one probably more on the political expediency side. The practical one is we've got 5 billion tons that is sitting around the United States of this stuff. Even now, with coal only producing about 16% of our electricity, we are making somewhere between 70 and 110 million tons a year still. Total hazardous waste capacity in the United States is about 35 million tons a year. So if we suddenly classified all of this as hazardous waste, it would completely overwhelm the system. The second reason is what we do with it. So what do we do with coal ash? Well, the first thing we need to do is obviously get it out of places where it could impact groundwater. But besides that, we've got two options. The first is you can actually just say you're going to dispose of it. And if you do that, then according to the new regulations, you actually have to go through and put it somewhere where it will not impact groundwater. The second thing you can do is say that you are going to beneficially reuse it. Okay. Obviously, if we classified coal ash as hazardous waste, then any beneficial reuse becomes much, much more difficult from a legal and regulatory perspective. When we think about beneficial reuse, it can be one of two things. The first is it can be encapsulated. If we encapsulate it, it actually is typically chemically bonded in some way, and so it can't leach into groundwater. Majority of this is in cement and drywall. So there is actually a certain part of that flue stream coal ash that when you mix it into cement, it actually makes the cement more durable. And so fully encapsulated, more durable product, people are like, you know, this is actually a good thing. It's good to reuse it that way. Another part of that flue stream is actually for drywall. So it is essentially gypsum. Synthetic gypsum, but gypsum nonetheless. And so we use it in that. The problem is that we also have unencapsulated beneficial reuse. And a lot of this goes for road beds. So when you're building a new highway, you essentially make the road bed. Now, is there concrete on top of that? Yes. Might there be groundwater that could still potentially flow through it? Maybe. But at least the top part can't have infiltration. What's the worst kind of beneficial reuse? When we use it for structural fill. And let me tell you, we can do that a lot, especially since there is a loophole around this structural fill material in the EPA regulations. There is basically no federal requirements when you have less than 12,400 tons in any given structural fill. That's about 900 dump trucks worth. Okay, so anything less than that, basically the federal regulations say you as the company putting the structural fill on the ground, you have to make sure that it is not going to be impacting the environment. But that's an internal determination, and you don't have to do any sort of documentation for it except say, yes, it's fine. That's it. Okay, so we've got this major issue. Now, some state regulations actually could help with this, but those also have some challenges. In some states, but not all, if you use structural fill, coal ash, you have to have a lis pendens or some other deed notation, which should work, except for the fact that we all know that anything that goes into a county register of deeds can be filed incorrectly. Marketable title acts over time will make it so that those are no longer found, and climate change is making increasingly hazardous the durability of any non-digitized records, and many county recorders' offices still are not digitized. So I have a solution that basically says we need to have a new blockchain that basically sets up an immutable and distributed ledger with an actual geospatial coordination system of where every single ton of coal ash would go, where it's been placed, if it's been put into beneficial reuse, where it's encapsulated, and basically those geolocations could then be used and accessed by Zillow, Google, you could actually figure out if the property you were buying had coal ash structural fill on it. And the digital records would make it so that we would have continued durability of where this would go. And we're going to be seeing the vast movement of this material because by later this decade, all of those locations that are unlined have to move their coal ash. They have to get it out of the water table. They have to move it to a lined location or put it into beneficial reuse. So we're going to see a whole lot of movement. And right now, there is not tracking to say where it is all going. I am not the person that says that every utility is going to do this perfectly, because likely they're not. So after telling you about groundwater contamination and a large waste stream, depressing you right before we go and have wine, I'm sure some of you are like, well, what in the world does this have to do for tax? And I'd say two things. First of all, we have some of these sites that are legacy that do not have current utility owners. So we've got orphan sites we're going to have to deal with because of the fact that we don't want this groundwater contamination to continue occurring. If we actually put a tax on every ton, small one, then that would make it so that we actually have a fund to deal with the orphan sites that we know exist. Secondly, we're going to want to know where it's going, because wherever it is placed could have a significant impact on local property taxes and could very significantly impair those property values. We heard a little bit in the last panel about property taxes, but I would say this is one more place where if we go later and find that structural fill has been placed where we didn't know that it was there, that has a very significant impact on the local property values. There's one town in Indiana, nobody knew that it had been basically completely built on structural fill that was coal ash, and the entire town is a Superfund site at this point. There actually is also some issues with the utility funded cleanup and some of the baseline values that were used to say that the area was clean when in fact it was not. So they're continuing to see really a decimation of local property values and therefore local property taxes because of this. And so to make it so that we don't start seeing those kinds of situations later, we need to know where this is going. So thank you. And just press this.
That does. Oh, cool. Awesome.
Okay, thank you. Good afternoon. I'm going to talk to you as promised about conservation easements. As a warning, I am obsessed with conservation easements, and I have far too many slides because I just can't help myself. But we'll try and stick to the ones that are tax, environment, climate change, which is also everything. Okay. All right, so some conservation easement essentials, just in case this is your kind of first exposure in any detail to it. Let me just tell you, we're talking about non-possessory interest in land, right? So these are not the people who live on this is not the, property students, right? This is not your fee simple ownership of land. This is a non-possessory land. It's like an easement or a servitude, but I want you to actually put aside the basics you learned about easements and covenants because it's its own creature and it doesn't follow those common law rules. They are usually perpetual. And I'll show you the different statutes, some that require them to be perpetual, one state that prohibits them from being perpetual. The tax code requires them to be perpetual for the ones that qualify for the tax deduction. Because they are something different than what we had at common law, right? So if we think of an easement, which is like your driveway through the land, your right to go hunting on somebody's land, all of those things were kind of developed over the common law. But we had this creature of this new desire of things we wanted to do, which we wanted to have the right to protect the environmental conservation aspects of somebody else's property. And it just didn't look like any of our common law arrangements. So to depart from the common law, every statute to make sure that these would be, every state to make sure these would be enforceable had to pass a state statute. And it is very tricky to keep saying state statute, and I will probably say it wrong several times. These state statutes all outline the acceptable conservation purposes that that state identifies as reasons that they think we should depart from our common law rules and let people enter into these agreements to protect the land. I'll show you an example of one in a few slides just to see the kind of variety of types of things that are allowed. They are, for that reason, a creature of state law. We have some commonalities across our 50 states, but you have to kind of be careful and look up your own state and the nuances that they have. But there's a federal tax overlay that is doing a lot of work here. Okay, this is like this is again, property basics 101, right? You have a deed of a conservation easement. I love Heather's point about county recorder's offices, because these are called also something different in every county. And if you want to do projects like I have, where you go and try and track them down, you have to, and sometimes a county will call them 5 or 6 different things, and you have to try and figure out what they are and what they're doing. But the basic idea is that the original landowner is giving up something that they would have otherwise been legally permitted to do on their land. Develop it is the most common one. I have a big, beautiful ranch land, and I'm giving up my right to turn it into a Walmart. And in return, what do I get for that? Well, I might get money for that. I might get a permit, a right to develop somewhere else. But a very common thing that I would get would be a tax deduction, and I'll go over that tax deduction. And we can also see that there'd be both a tax deduction for me donating this very valuable property right, and also probably some property tax deductions for me reducing the fair market value of my property. So you could have a lot of tax benefits, as well as estate tax benefits that I'll just leave aside for now. Or forever, probably. Now, who is like holding this right? Well, the government, a government entity, or a nonprofit organization, mostly 501c3, but not necessarily. But they're the ones who hold that right. What does it mean to hold a conservation right in somebody else's land? It means that you have the right to go on their land and make sure they don't build a Walmart, right? So this is like the essence of this agreement that we're dealing with. But I hope that without too much trouble, you could quickly think of how complicated they could get, how many people are, who actually are the people out there enforcing them? Are they good at that job? Do we really think that the conservation purposes are all that great? But at the same time, we might be very excited about them when you have a government that's not so interested in land conservation. Maybe you're like, thank God, we don't need to rely on the government to protect land. We can go and use this private environmental governance mechanism and get some bang for our buck that way. So these are all like the exciting features about it. This is a slide that I know these words are too small to really process, but let me just show you the big green chart there. What's the reason why this is, why we should care side is that we are just increasing our use of these tremendously. And we haven't always thought about how they're done. And because they're perpetual, once you are, like, think of that as like cumulative, right? Those are like, you can't quite see the bottom of that chart, but it's the total easements over starting about 1960 and going forward. We're having more and more conservation easements are being entered into, and that's cumulative because once they're entered into, they're lasting forever, right? So we're kind of have a lot on the ground. And as they get older, we might be not so good at figuring out where they are anymore. And those organizations that have agreed to keep an eye on them might not even be around anymore. So we have a lot of concerns about what's going on with these. This is a a nonprofit organization called the National Conservation Easement Database, NCED. They try and track easements. These are the 2016 numbers, and it says 130,000 easements, conservation easements, 24 million acres. This is the one I got this morning, maybe around lunchtime, that says 221,037 million acres. They themselves would say their databases only has about 60% of the easements. So about 40% that we're not quite sure where they are, but just to show you kind of our numbers that and the pace of how we're growing. The Land Trust Alliance, so those nonprofit organizations that can be the holders, the enforcers of the conservation agreements, they have to be environmental organizations that have conservation as one of their central purposes. So these are not the other environmental nonprofits you might be familiar with. This is not the Sierra Club. This is not Audubon. It is the Nature Conservancy and Trust for Public Lands, but they have a slightly different mission that's specifically about holding and protecting land. The number of those organizations has also continued to grow. And some of them are all volunteer, 100% volunteer organizations. So just think about that also as we're thinking about this kind of perpetual legal restriction being enforced by all volunteers who rarely have any training in law or conservation biology or tax economics. But what I also wanted to show about this, again, let me just kind of explain the slide because it's probably hard to read, which is that they work both by protecting land through conservation easements, but also through fee simple, just purchasing the land, which gives them more control and a larger ability to ensure the protection. But the little yellow line there at the bottom, it shows the trajectory for the acreage that they are buying fee simple, that they're purchasing the full rights to the land. And I just want to point out how that's pretty steady, whereas the use of the conservation easement is increasing, right? So they're really turning to that as their preferred method of land conservation. It's cheaper, it's more flexible, it's easier to get somebody to sell you their development rights perhaps than to get them to sell you their full title to their land. This is, again, this shows kind of the same thing. The Land Trust Alliance, an umbrella organization for these nonprofits, has every 5 years they do a census. That's where the last slide came from. This one is the 2020 census, so we should expect another one soon. And what I want to show there is the plus 58% under conservation easement, whereas only plus 17% under owned, right? Just showing you again that this is really, they're embracing this tool as their favorite way to conserve land. Now, conservation easement law, to study this, you need to think about so many different areas of the law, right? Obviously, property law, and property law is my true love. Property law, and then there's all the state enabling acts, but then tax law. And as I said, this is income tax, estate tax, property tax, trust law. We would, if Nancy McLaughlin was here instead of me, she would be telling you also that charitable tax laws, charitable trust laws are playing a big role in shaping how these things are interpreted over time as things change. And that also means that we're looking at kind of state laws about charitable organizations and how they operate and making sure that they're legitimate organizations, which is a concern. All right, but these are what I want to talk about, just these two pieces of the many aspects we could get into, the state enabling acts and the federal tax code. The state enabling acts are what say that these are going to be enforceable, which is why you could enter into this agreement, take it to court, and it would be enforced. But the federal tax code explains how you could get a federal tax deduction for entering into it. Now that means that you should only really be thinking about the federal tax code when it was a donated conservation easement. That is a big chunk of them, but it isn't all of them. But many organizations, just once they kind of have a way of operating, like they'll just treat all of them like they're under the federal tax code, even if they don't actually maybe need to follow those federal tax rules. So this is just an example. This is the Uniform Conservation Easement Act, an example of what our state enabling acts look like. But around 20 states have adopted this. There's a lot more variety in these, but they set out like the types of purposes I was saying, oh, for open space, for natural, for scenic. And then you can picture how your state might change this list a little bit based on your state's priorities. But what's really driving things quite often is what the IRS has said are acceptable purposes. And so just to point out the ones that IRS likes: outdoor recreation, relatively natural habitat, open space, including farmland and forest land. But only if that open space is either good for scenic enjoyment of the general public or is subject to some clearly delineated state or local policy that's already in existence. Also, historic structures. We wouldn't have to go far in this neighborhood, or we could just wander over to Brooklyn and we'd see there are most of those that have probably historic preservation easements on them. So what are their purposes? We think of environmental as what they're doing, but a lot of these are over working landscapes, agricultural and forest lands. Some of them are historic architectural sites, some of them are archaeological sites. But there's a lot of concerns with them. So what I want us to think about is these tax benefits that are being given to these individual landowners, and whether we really think that that tax benefit, that very valuable deduction they're getting, is worth the impact on the environment that we are all receiving. Like, have we made a good deal by allowing these, or would we have been better off using that money for other environmental actions? So this is just to say the state law does not require them to be perpetual, but the tax code does. 4 states require them to be perpetual. North Dakota prohibits it, but the IRS requires it. So what's the problem with a perpetual restriction in a changing world? I hope that title enough is it tells you, like, these are static agreements. So maybe written in 1960, and it still operates. They are very hard to change, right? They're supposed to be perpetual. They did not contemplate climate change. They don't contemplate other social changes that we might be interested in. So they're very hard to change. Some people actually argue they're too easy to change because we have very few eyes on them. So you might have people who are just negotiating and changing them, and all of that public benefit, which suggests that there should be some kind of public oversight, we might not have much, if any, of that. There's also ecological reasons that we might be worried about them. We might want to actually be able to change them to, like, because the ecology of the area has changed. They're also, let me see, they're also very ad hoc. I love, Alice said, what is it? Tax law can't plan. I loved that because this is it's just like where landowners have enough money that the tax benefit is going to be valuable to them. The tax benefit, we figure out what's the value of the land with the conservation easement and without the conservation easement. We do that calculation. They can take that as a tax deduction that they can spread out over a few years. Not everybody has got to have enough income that that's going to be a valuable thing to them. And so we see that they're piecemeal, they're over marginal lands, and the restrictions might not be adequate to meet our environmental goals. Okay. I'm going to skip over this one, which is even though it's just to say, we are very uncertain of our public benefit. They suggest that they should have access to them in the IRS language, but we see actually that I don't know how to point, but the big red squares, the big red circles actually showing us that most conservation easements lands are closed to the public. And then the purple one is unknown. So kind of like Heather's slide, probably also closed to the public, showing that even though we think of them as being kind of there for public benefit, we don't have public access to them, but there might be other public benefits. And here's my quick tax slides. We've got lots of sketchiness happening here. We've got them protecting golf courses. We've got them protecting historic buildings that were not in threat of being changed. So this is a funny example in Buffalo where they took the tax deduction twice in ways that I don't quite understand. In people's backyards, getting big tax deduction to like not mow your backyard. And then you have to think are people actually going in their backyard and making sure they're doing that? The Dirty Dozen, they were different types of conservation easements have been on the IRS Dirty Dozen list quite a few times, including the syndicated conservation easements, which last year they did kind of create a new rule to kind of, what's this tax phrase for this, where you keep a special eye on it? I don't know. They're keeping a special eye on it, and they're going to do a lot more audits if they see something that looks like this, because what's happening, you could picture this, people are like, inflating those valuations. They're kind of creating these like really bogus structures. This is why I said we also have to think about who are these people overseeing them. And so we have a lot of problems there. All right, I know I'm over time, so I'm going to take an extra minute anyways, which is that, and then we can think about conservation easements and climate change. I've hinted at this a little bit. Here's a big survey we did about 10 years ago now. We asked all these land trusts, are you concerned that climate change is likely to influence the region where you protect your land? Absolutely. Although some didn't. It was 10 years ago. Do your conservation easements include provision for climate change? 97% said no. Like, it's just not in there. They're not thinking about it. Now, a lot of them would say, we still think it's probably flexible enough in there that would be okay. But some of them have very specific language, like this is to protect oak woodlands, and then you have land that you can't have oak woodlands on anymore. And then this, I can't resist, because we were talking about soils earlier. This is another struggle we see. We've been talking a lot about taxes and climate mitigation, but this is really a lot on adaptation side on this one. So this is like the habitat for the bay checker spotted butterfly in orange there today, but this is where we think it's going to be. And so we haven't actually protected the right lands for that, even though our climate change model shows where it's going to move to. And then if we add our soils, because the soils don't move, if we want to save the stage, as we say, those aren't in the right places either. So we're not kind of targeting the right lands with it. So we've got a lot of different reasons why climate change and these don't mix. All right, I think that's it. Yeah. All right. So thank you for your indulgence.